An appeals court has cleared the way for President Trump to continue using National Guard troops in response to anti-ICE protests in Los Angeles. However, the judges rejected the administration's arguments that the courts don't have the power to review whether the president is allowed to call up the Guard. CBS News Department of Justice reporter Jake Rosen is tracking the latest from Washington and joins me now. So, Jake, break down this ruling and the implications it could have between the judicial and executive branches.
Well, that's right, Vlad. All three judges, including one that was appointed by President Biden and two by President Trump, all agreed that California's concerns were too speculative as to calling in the National Guard, potentially inflaming the protests that we've seen in Los Angeles. The judges did not buy the Trump administration's argument that these decisions by President Trump to call in the National Guard and the Marines are unreviewable, which, at least to one immigration advocate and attorney, really was positive news, as we've already seen the back and forth between immigration lawyers and the Trump administration really escalate. Take a listen.
It also opens the door for a review of an executive power or military affairs, and that is a very important precedent that will be debated in the Court of Appeals likely, but it opens the door to at least challenge certain executive power.
And so right now, the Newsom administration can do one of two things, Vlad. They can either ask the entire circuit of appeals out west to look at this, it would be 11 judges, or they can go straight to the Supreme Court if they decide to continue challenging this. Otherwise, for now, the president can remain in control of those 4,000 National Guard troops and those Marines. And there's a hearing scheduled still for later today out in California. It has not been canceled yet, in which California might try to provide different arguments as to why President Trump's federalization of those 4,000 National Guards is unconstitutional.
Jake, as you know, judges also ruled the Trump administration cannot require states to cooperate with ICE to get transportation funding. This is part of a larger effort from the White House to push back against sanctuary jurisdictions. What can you tell us?
Yeah, and Vlad, we've seen this across every part of the Trump administration so far, whether it's medical grants, whether it's public safety grants, anything else. What we've seen in this specific case was a group of Democrat-led states which sued, claiming that funding for things like public rail, public roads, federal funding to airports, all of that was being held up unless these states cooperated with ICE and the Department of Homeland Security. A judge in Rhode Island found that that was unconstitutional and that there's no reason legally that the Trump administration had to withhold any of this funding because it is mandated through Congress, not the executive branch. Certainly another blow to the Trump administration's attempts to kind of leverage the power of funding, especially to places that these states need, right? Federal roads and federal funding for transportation in case these states decide to not cooperate with ICE, as many have decided to continue to not do. Certainly something to keep monitoring over the next couple of months, as on both of these fronts, the Trump administration continuing to remain defiant and go into these Democrat-led states to do and enforce their immigration agenda.
All right, Jake Rosen for us. Thank you, Jake. Appreciate it.